Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. You may be seated. The case before this court is Danny Marston versus the state of Cardozo. Petitioners, would you like to reserve time for rebuttal?
1 minute, please.
May we have the name of all counsel first? And that's who you.
Kristen Niven on behalf of Petitioner Danny Marston.
Welcome.
Adam Rick, also on behalf. Jonathan Wilcon for the respondents. Brett Ruber for the respondent.
Very good. Helen?
May I proceed?
You may.
Good evening, Your Honors. May it please the Court. I'm Kristen Niven on behalf of Petitioner Danny Marston, who raises a Confrontation Clause challenge to his conviction of felonious assault and child abuse in the state of Cardozo. And the petitioner specifically asked the Court to consider the question of whether a statutory mandatory reporter of child abuse may be considered an agent of law enforcement for the purposes of the Confrontation Clause under the Sixth Amendment. Would the Court like to hear a brief recitation of the facts?
Sure.
Very well. In October of 2012, the petitioner dropped off the son of his partner at school. This son was a 7th grader. And while at school, the child was confronted by his teacher, who approached him, noticing that he had a cut-like mark on his chin. The teacher, Alexandra Cabot, asked him what had happened, and the child responded that he fell. The teacher was suspicious, so she went to the guidance counselor's office and sought out what her duties were under this mandatory reporting statute of Cardozo Social Services Law. Immediately after approaching the guidance counselor and finding the statute, she encountered the school police officer, Officer Munch, who asked her, he had overheard the conversation, he asked her what had happened.
Can I ask, how important is the contact with Officer Munch to your argument? If there was no contact with the law enforcement officer at all, how do you think that would affect your argument?
Your Honor, I believe the contact with Officer Munch is a factor that weighs in favor of the fact that of the analysis under the primary purpose test of this court's jurisprudence that would indicate that the purpose, objectively speaking, could very well be a law enforcement purpose to elicit testimony.
Was there any coordination between Officer Munch and the teacher?
The Officer Munch, he did ask the teacher to let him know if she found anything, and she replied, okay. And then she returned to her classroom where she encountered the child again and found she noticed another mark on the child, a bruise on his shoulder, and that's when she approached the child again. And this time her line of questioning asked, who did this?
But she never reported back to Officer Munch.
She did not.
So how can you argue that she was an agent of law enforcement?
Your Honor, given the totality of the circumstances, there are several factors that should be considered. As this court said in Michigan v. Bryant, the actual content of the question and answers may be a very strong indication of what was the purpose of the conversation between the declarant.
But wasn't the content of the conversation that she had with the child driven by what she perceived to be her duties under the statute to report?
Your Honor, that certainly could be one interpretation since she looked at the statute, but another one, because of her encounter with Officer Munch, she was certainly aware that this was also a criminal issue. She has 20 years of experience in teaching. Certainly she would have been aware that child abuse is a crime as well as something that needs to be protected.
If her intent was to further a criminal prosecution, why wouldn't she have reported back to Officer Munch or to have called some other law enforcement agency instead of Child Services?
And let me ask a related question to my colleagues, which is, how important is Cabot's subjective concerns in this case? Should we be wondering what she actually hoped to achieve, or should we be looking more objectively at the circumstances to decide our job here is to make rules for the entire nation? And so do we want to send the district courts to be looking at every single individual interrogator, that person's subjective intent, or should we be looking at objective factors?
To address your question first, Justice Netburn, the objective analysis is what has been the standing rule. So an inquiry into the subjective purposes or intents could be very problematic under the Sixth Amendment analysis, particularly because it's very difficult to determine. And also there could be multiple subjective purposes happening at one time, but what the primary purpose is something that must be determined objectively. And also as far as her not approaching the officer or the police department immediately after this encounter with the child, I believe that the facts do indicate that she could very well still have had a primary purpose of law enforcement, of eliciting a testimonial statement, and that this could be used for later criminal prosecution.
Well, wasn't she required to report by the statute?
Yes, she was.
And doesn't the statute make a distinction between what it purports to be doing and a criminal investigation?
Yes, Your Honor. The petitioner does not argue that the statute by itself necessarily makes a mandatory reporter an agent of law enforcement. However, Ms. Cabot's actions went beyond the scope of the statute, and she, in fact, by asking who did this, the statute does not require any indication of a suspect or an accused. It only requires that she have a reasonable concern for the welfare of the child, and the mandatory reporter does not need to investigate into who a potential criminal defendant might be, who is responsible for the child abuse.
Wouldn't that be a natural question? She's a teacher. If she believes that a child has been abused, and if it happens to be a parent or a guardian coming to pick that person up at school, wouldn't that be the most natural question to ask? And asking that question, does that turn her into a law enforcement officer?
Your Honor, I would argue that this question and the pursuing of this question, she was relentless in this line of questioning, in fact does weigh in favor of her being a law enforcement agent for this purpose. And to address your earlier question,
you said that she was relentless. I mean, she asked 4 or 5 or 6 questions. And doesn't she have a responsibility to determine, is this child abuse, or is this a kid who's on the wrestling team, or a kid who's roughhousing with his brother or sister, before, making a report to the authorities?
Her duties only amount to, they only are triggered by a reasonable cause to suspect child abuse, which only amounts to a concern for the child's welfare, their well-being. So her duties to report begin and end with concern for the child, but I believe she went beyond that scope when she investigated into who was responsible. This is not required by the statute, and she could have handed over the whole inquiry to the administrative agency, to CACS, to investigate, and if they wanted to bring in law enforcement, which in fact they did later on, this is something that she could have entirely relieved herself from. However, she not only elicited the statement about who was responsible herself, but she conveyed that very fact to the administrative agency, and the same fact was carried through all along an unbroken sequence of events right to law enforcement. At no point.
Sorry, the cases seem to distinguish in the context of whether a statement is testimonial versus non-testimonial about the need to, if you're looking to deal with an ongoing emergency situation, and I think everybody in this room would agree that if a child is in an abusive home, that is an emergency situation. And so why isn't her inquiry to determine exactly what the scope of this situation is, why isn't that more akin to the cases that discuss the non-testimonial nature when you're seeking information for an ongoing emergency?
Your Honor, I would like to make 2 points to that question. One is that the emergency factor of whether something is a non-testimonial statement has applied in this court's jurisprudence only in the situation where law enforcement was directly interviewing or interrogating an accuser. So this was only a dichotomy that was drawn for what are the purposes a police officer might be asking questions of a person. They're either for criminal investigation or they're to respond to an ongoing emergency. But the court was very clear in Michigan v. Bryant to say that this is not the only situations. These aren't the only two situations under which a statement might be considered testimonial or non-testimonial. And so for that reason, the fact that whether or not there was an emergency is not the sole determinative issue here. And secondly, the court
if the primary purpose is to meet an ongoing emergency and here supposedly a child being battered, removing the child from that environment, that's non-prosecutorial. So why would we consider it testimonial?
Your Honor, the petitioner also takes the position that this was not an ongoing emergency, as the federal courts have interpreted such situations. For example, the Fourth Circuit Court of Appeals in U.S. versus De Leon, in fact, did find that the mandatory reporter was not an agent of law enforcement, but allowed for the fact that this very similar set of facts was not an emergency. An emergency is not required.
If the guardian, Morrison, had pulled up with his car in front of the school, was ready to take the child, would you consider that an emergency?
Your Honor, the fact that there's no imminent threat in the way that there was in Michigan v. Bryant, where there was an active gunman on the loose, I believe that this is not an emergency.
Then tell me why the child was removed from the household.
After a further investigation by the CACS, the child was removed from the household, but the fact remained that the inquiry from where it started with Ms. Cabot through the CACS all the way to the law enforcement was skewed by the fact that there had been an accusation.
I think you have about 1 minute, so if you want to summarize your argument,
Thank
here's
you,
a
Your
wonderful
Honor.
opportunity.
The facts of criminal investigations and trials can virtually vary infinitely, but what is at stake is the balance that the Sixth Amendment seeks to strike between a state's law enforcement arm and the individual rights of its citizens. And a bright line rule, such as what the Cardozo Court of Appeals drew, that a mandatory reporter can never be a law enforcement, would fly in the face of the Sixth Amendment's purposes and this court's jurisprudence, which demonstrates that this is necessarily a fact and circumstances-based analysis, and no particular factor, including whether or not they're law enforcement, is dispositive. Thank you, Your Honors.
Thank you.
Thank you very much.
Proceed, please.
Your Honors, may it please the Court. I'm Adam Riff. I represent the petitioner, Danny Marston. I'll be speaking to the issue of the Fourth Amendment violation by the state. Your Honors, this is a case where two investigating officers converted a purportedly specific warrant into a general and unrestrained one. The Court should reverse the judgment of the Court of Appeals for the following reasons. First, if this Court finds for the respondent in this case, it will be a departure of your 225-year history of abhorrence for general warrants. Second, in your decision in Horton versus California, where you rejected the inadvertence requirement to the plain view doctrine in the context of physical searches, that decision was inapplicable in the context of electronic searches. And so, when the Court of Appeals relied on Horton to reject the inadvertence requirement in the context of electronic searches, that decision is constitutionally infirm. And finally, the inadvertence requirement must be incorporated into the plain view doctrine in the context of electronic searches. And because it wasn't satisfied by the officers in this case, their search and seizure was in violation of the Fourth Amendment.
I'm sorry, you're asking us to overturn a prior decision of this court?
Absolutely not, Your Honor. This court can find for the petitioner without disturbing the holding in Horton versus California. The decision in Horton was absolutely correct in the context of physical searches. You relied on three rationales that
Why isn't it correct here? And why is this a general warrant? The warrant authorized law enforcement to look for evidence of child abuse in a computer. That seems rather specific.
Your Honor, I'll begin with your second question.
Go ahead.
The reason this is a general warrant is because, as several federal courts have noted, including the Fourth Circuit in the United States versus Williams, because of the ease with which information is obscured in the electronic context, then, as the Fourth Circuit said, investigating officers have an implied ability to look at each and every file on the computer in the course of their search. Combine that with the plain view doctrine, and that means that puts officers in a lawful position from which to view every single file on the computer. So,
how is it any different if a warrant authorized officers to search a home for unlawful drugs of pill size? They'd be able to look in every drawer under the rug, in every nook and cranny.
Your Honor, the protections...
Would
yeah.
they be authorized? So why is this any different? Why can't they look into every electronic file looking for evidence of child abuse?
The protections afforded by the particularity requirement of a warrant, which would address the concerns this court has had with regard to the Fourth Amendment in the physical context, do not offer the same protection in the electronic context. And to illustrate that for you, if there's, as this court has noted in the past, if the warrant is for a lawnmower, the warrant would not authorize the investigating officers to search a bedroom. It would authorize the officers to search perhaps a garage. If it's for...
Why not? Because as soon as that decision came out, the stolen lawnmowers are going right into the bedroom thereafter.
Well, Your Honor, in that case, then perhaps there's probable cause. If the neutral detached magistrate believes that there is probable cause for lawnmowers in bedrooms, then absolutely.
Well, here's where I think is part of the difficulty of your position. And taken from the facts of this case, they found this incriminating information in a folder which arguably you said they should never have looked into, correct? But that's what criminals do. They hide things in places where law enforcement is not likely to go. So why should we handcuff law enforcement officials from looking into places where the bad guys, being bad guys and wanting to remain out of prison, are likely to hide the information?
Your Honor, the petitioner's position is slightly different. We don't dispute that the officer could have opened up that first file, the ledger. What the officer should have done at that point, once the ledger was open, was go and get a warrant.
Let's talk about that. I mean, what are the practical policy implications for doing that? We have hundreds of thousands of ongoing investigations happening all the time. To stop the investigation and get back into federal court or state court, get before the magistrate judge in order to sign the warrant, isn't that going to cause an unnecessary burden and delay in the system?
Well, for one thing, Your Honor, the petitioner does not minimize the importance that this court has placed on warrants in the past. Just last year in Riley, the court noted the importance of investigating officers going before a neutral and detached magistrate to assess the probable cause, as opposed to the officers who are engaged in a often competitive search for forensic evidence, instead of the officers making the decision in the field. We believe that, again, here's an important distinction between the physical context and the electronic context. Often, there are legitimate concerns, as the court has recognized in Horton, in the physical context of safety to the officers, of possible destruction of evidence. In this case, those concerns were not present. The officers were looking at a copy of the hard drive.
But every one of those files may have had evidence of child abuse, and the officer couldn't exclude that possibility until he opened the file. Would you concede that?
Yes, Your Honor.
So therefore, every time a folder was opened, a file, and the officer had to determine whether or not there was child abuse, if he saw readily apparent evidence of a crime, that's in plain view, no?
In order to be able to use that evidence at trial, all the officers need to do is get a warrant. The challenge...
Even if the officer saw evidence of a crime in one file, why do they have to get a new warrant if they're still operating under the current one for child abuse? Aren't they permitted to look into every file to assure themselves that there's no sign of child abuse there?
once the officers in this case converted their search from a search for evidence of child abuse to evidence explaining the criminal nature of the ledger that they had opened up, that's when they began operating outside.
Well, now you're using a subjective test. Should we be applying that?
Your Honor,
you're challenging the motives of these officers, these fine officers.
Your Honor, the petitioner's position is that an inadvertence requirement is necessary in the electronic context to protect all of the things about the Fourth Amendment that this court has prioritized over its many decisions. The fact is, it frankly, under the rule enunciated by the Court of Appeals, it frankly didn't matter what the warrant authorized the officers to search for, how particular it was or not. Those officers could have opened up, under the Court of Appeals rule, each and every file on the computer looking for any inculpatory evidence of any crime inculpating anyone.
No, they were just opening every file for child abuse. What was wrong with that? Even if they opened up file A and it indicated that there were drugs, why did they have to stop to get a warrant if they wanted to still look in file B, C, and D for evidence of child abuse?
There may be a case where investigators would continue searching for evidence of the crime authorized in the warrant. Under the facts of this case, the officers, believing that they could search for anything, were in fact shifted their search from a search for evidence of child abuse to search.
But you make it sound like it was a purposeful change on their part. From their perspective, they would say we didn't convert it; it was converted by our looking at these files, which we had every right to do.
Your Honor, once that first file was opened, the burden of going to get an additional warrant that would authorize them to search this new crime that they'd embarked on a new search outside of the warrant, that's all the officers needed to do in order to satisfy.
Wasn't that
the things I found problematic about the officers' conduct here is the nature of the two different crimes. Looking for evidence of child abuse is likely not going to be on a ledger. I think it's a highly unusual that a child abuser is going to keep a daily record of the nature of the abuse. And so from my perspective, I think the fact that the documents were so different and the nature of the crime was so different, but I don't know if we can draw a rule where we're looking at sort of case by case, crime by crime. I mean, if the crime was for fraud and they came across other bank statements that ultimately showed drug dealing, it would be, I think, a closer call. I don't know if you have thoughts on that.
Our position, Your Honor, is that the intent of the officer is the only guiding factor that can protect the concerns that you've enunciated about the Fourth Amendment, and that should be the separation. So when officers are conducting a search for evidence of one crime, and this situation, you're right, Your Honor, it is particularly stark that they began searching for evidence of a different crime. But when the officer's intent looking for different evidence converts, that's the mark where the officer needs to go to the neutral detached magistrate and get a warrant.
Your time's almost up, so we'll give you an opportunity to sum up with a couple of words if you'd like.
Thank you, Your Honor. If this court allows I see my time is up. If this court
we'll give you 30 seconds to make your point.
Thank you. If this court allows the Court of Appeals decision to stand, it will effectively sanction general warrants in the electronic context, and this court can reverse the judgment of the Court of Appeals without disturbing your holding in Horton or any other precedents. Thank you.
Thank you. Counsel for respondents. You may proceed.
Good evening, co-counsel, petitioners, Chief Justice, Your Honors, may it please the court. My name is Jonathan Wilcon, I'm representing the petitioners, the respondents, and I will argue that the Court of Appeals was correct in light of Social Services Law 413, on the law and on the facts, in light of the weight of authority, and on the facts of October 8th. The Court of Appeals was correct. Cabot was not acting as an agent of law enforcement. Social Service Law 413 did not deputize her. And even if she were deputized, these statements are firmly within this court's jurisprudence of what constitutes non-testimonial statements. First, the statute. Social Services Law 413 did not deputize Alexandra Cabot because 413 is not a law enforcement statute.
But what's the purpose of the statute?
The purpose of the statute is to protect the welfare of children. The record is silent on the purpose of this exact statute, but we can look at other similar statutes. For example, Connecticut. The stated purpose there was to protect the welfare of children and to strengthen the family. Now, contrast that with other statutes that are similar, but that have one striking characteristic that is fundamentally different. That is a mentioning of law enforcement. The statute here does not contain any mention of law enforcement. On the other hand, the statute in Clark, for example, out of Ohio, Public Health Law 2151.421, contains the exact phrase that the investigation by Child Services shall be in cooperation with law enforcement.
But even so, I mean, doesn't it just make sense? And weren't they really driven at a certain point by the need to prosecute the individual responsible for beating this child? I mean, didn't everyone know that this is what was going to happen?
No, Your Honor. On the contrary, if you look at the facts and circumstances that these conversations took place in, they were in the normal setting, time, and context that these two people normally interacted. This court has said...
There was a cop in the school that said to the teacher, I want to know what's going on. Let me know what's going on with respect to this. Let me know if you learn anything. That's not what happened when I was in school.
That conversation with police did occur. It did contain the crucial word, if you find anything, and it did not affirmatively command her to go and search, to go and investigate. Neither did Social Services Law 413. There's nothing in the statute that commands her to investigate. And when we look at the exact circumstances of that conversation, it does not rise to the level of coordination, of working at the behest of law enforcement. When we take a look at cases...
Would you say it encouraged her to proceed? Well, let me know if you find anything. And her questions were the type that a prosecutor would be asking of a victim, no?
Well, her questions were
and focused on the perpetrator, as opposed to how to get the boy to a safe place.
Sure. Well, to deal with your quick question first, her conversations contained 2 statements about who, 1 statement about when, and 2 statements about what happened. So this wasn't a focused inquiry solely on the who, but it encapsulated all aspects of how these injuries caused. And to return to your question, the circumstances here were in the same time, setting, and context. They were upon the contemporaneous discovery of injuries. Her actions were not the actions of a cool, calculated prosecutor or law enforcement representative in a room with a 2-way mirror, with a pen and paper or video recording. These were upon the contemporaneous discovery of injuries. She walked into her classroom. The student walked in from the lunch break, out at recess, perhaps being bullied by another student, and she immediately witnessed the injuries. She didn't pause. She didn't separate the child into another room. If we look at certain other cases, for example, People v. Phillips, that law required the teacher to report to police, and in that situation, there were multiple conversations with the student in separate places, and this court still ruled, the lower court in Colorado still ruled that that was a conversation eliciting non-testimonial statements and that the teacher there was not acting as an agent of law enforcement. And when that case came up on appeal in 2012, this court denied cert.
Didn't she naturally know that she was setting the ball rolling towards engagement by law enforcement when she called up social services?
She may have, but the primary purpose test is an objective test about the primary purpose. It's not the dual purpose test. It's not the any purpose test. So from an objective standpoint, any person might know that law enforcement might be involved, but what is that person's primary purpose, and what do the facts of the situation show from an objective standpoint was most likely their primary purpose?
Are we to look at the primary purpose of this individual or the primary purpose of the reporting statute?
The primary purpose test is focused on the primary purpose of the person eliciting the statements and the purpose of the person making the statements. There's been some split in the jurisprudence, particularly Scalia's dissent in Davis was arguing that it should be more focused solely on the person making the statement. Of course, that was a dissent, so there's somewhat of a split there, but nevertheless, the point remains. The primary purpose is about the primary purpose of both the declarant and the person eliciting statements.
Is that what Justice Sotomayor said in Bryant? What did she say?
I do not recall Sotomayor's specific decision in Bryant. However, Bryant is a fundamentally important case here, of course, and in Bryant, they discussed that statements that begin as non-testimonial may eventually become testimonial. So this court need not be concerned about cabining all statements by a student to a teacher as forever being non-testimonial.
But isn't that what happened here? She became concerned because the child had injuries. She asked him how the injuries came about, and then she asked, well, who did this to you?
Precisely. She was concerned with ascertaining whether there was an ongoing threat to this student. The student had just come in from lunch. She had witnessed on multiple occasions that he was beginning, to display evidence of psychological trauma. Now on October 8th, he had a cut on his chin, he had bruising, he had just come in from being in a situation outside of her observation. And she said, who did this to you? Is there a threat outside? Is it a bully that you're going to encounter on your way home from school? The facts here certainly are not as dramatic as Anthony Covington bleeding out on the side of the street, but in Bryant, of course. But in Bryant, the police officers were asking him who did this. And as much as it's easy to say there was an active shooter.
And that was determined to be non-testimonial, right?
Precisely. Those were non-testimonial statements.
But that was a case where a person had been shot.
Right.
Go ahead.
But the fundamental purpose in their inquiry was determining whether there was an ongoing threat, as there was here. Who did this to you? What happened? Do I need to be concerned about the janitor, another student, perhaps another teacher?
But the questions here were directed towards past events. What had occurred? Who did this to you? What did he do to you? Those were all past events, no?
As much as they were in...
So whatever had occurred to the child had occurred before.
Well, as much as they were in the past, there was 2 conversations and a discovery of a new injury sandwiched between those conversations. So the discovery of injuries was contemporaneous with the multiple inquiries into what was causing these problems. Of course, in Bryant, there was no shooter right there. Police officers had not drawn their guns, although he was currently bleeding out on the street.
But the ongoing emergency there was with a man with a gun on the street.
The ongoing emergency there was that there was a man bleeding and they weren't sure whether there was a threat to him at that time. The shooter, if you recall, was not on the street there. He was in a house several miles away, I believe. And the fundamental purpose of their inquiry there wasn't to investigate how to deal with an ongoing emergency. It was to ascertain the fact of, is there currently an ongoing emergency? Just like here. She had to determine, was there an ongoing emergency? And this case doesn't hinge on the ongoing emergency exception.
The child wasn't threatened, was he? Was the child in any sort of immediate threat in the school, surrounded by a teacher, by a police officer close by?
Cabot had no way of knowing that until she asked, who caused these injuries to you, and under what circumstances were they caused to you? At that point, she found out how they were caused, and then she complied with her statutory obligation. She didn't separate the student, take out a...
But this case isn't like the Hammond case, where there's a beating in progress, and a woman calls up 911 and says, I'm being assaulted, I need help, a cry for help. Was this a cry for help?
This is precisely opposite of Hammond, because in Hammond, the police arrived on scene to a domestic disturbance and knew the cause was the husband, who was in the other room with a police officer, while the officer eliciting statements was in a separate room, they knew there was no ongoing threat because they knew the cause of those injuries. Here, she did not know the cause of those injuries or how they came about, under what circumstances, and needed to find out, how did these come about? Now, as I said, this case does not hinge on the ongoing emergency exception by any means. We see in the medical treatment context statements that are attributing fault to the cause of injuries, particularly in the domestic violence context and particularly in the child domestic violence context, have been held to be consistent with the medical exception that do not implicate the confrontation clause.
What rule would you present for us? Is the rule so sweeping that it's, and given that there's all 50 states have mandatory reporting requirements, should the rule just be that mandatory reporters can never be law enforcement agents for purposes of confrontation clause analysis, or what rule would you recommend that we adopt?
Certainly not. This court need not go that far to say that under no circumstances could they ever. Solely that when a teacher responds and discovers injuries and pursuant to a statute that has no law enforcement implications, and she exhibits the same care and concern that any normal adult would exhibit, or that we would hope they would exhibit, that she's not acting as an agent of law enforcement, where she hasn't had any direction by law enforcement, no instruction as to how to go about that inquiry, as to who to question. Certainly the statement, "Let me know if you find anything," does not rise to the level of coordination or operating at the behest of.
So you don't think there's any dispositive factor? You would adopt a multi-factor test that we would just throw back to the lower courts to apply?
Well, pardon me, may I just finish this answer and then conclude? Thank you.
We'll give you an opportunity to answer the question and then very briefly sum up.
Thank you very much. I'll try to be brief. As for a specific rule, this court has shown on many occasions that it's comfortable remanding to courts to apply multi-factor tests similar to the primary purpose test. This case is within the primary purpose test. The facts of how the how the conversation went, the facts of the text of Social Services Law 413, these all indicate that this is within this court's jurisprudence of what non-testimonial statements are. For those reasons, we will ask that you affirm the Court of Appeals.
Thank you.
Thank you.
Counsel?
Good evening, Your Honors. May it please the Court. My name is Brett Ruber, and I am here on behalf of Respondent State of Cardozo discussing the second issue in front of this Court this evening. Petitioner urges this Court to overrule, in an electronic context, its decision in Horton v. California rejecting the inadvertence requirement, claiming that the intent of the officer is the only thing that can protect people from unreasonable searches and seizures.
Do you lose if we don't overrule Horton, if we stick by our precedent? Are you out of luck?
If you stick by your precedent, I would...
We like Horton. How are you going to do under Horton?
We do well under Horton, Your Honor.
Okay.
The Horton test is an objective test, and we believe that warrants, in a conjunction with an objective test, adequately protect the Fourth Amendment interests of defendants. The Horton test has three prongs. The first prong is that the officer must not violate the Fourth Amendment in arriving at the place from which the evidence could be plainly viewed. Second, the incriminating character of the evidence must be immediately apparent. And third, the officer must have a lawful right to access the object itself. In this case, all three of those prongs are met.
How do you deal with...
Sorry, go ahead.
How do you deal with the issue that I raised to your adversary, that the officers were looking for evidence of child abuse? And as I said earlier, this ledger was not going to have child abuse. And so it may have been plain on its face that this was evidence of criminal activity, but it wasn't evidence of child abuse. Why couldn't the officers stop right there and get an appropriate warrant that extends the scope to focus on the illegal activity that they now see as existing?
Your Honor, we don't argue that they could not have gotten a warrant, certainly, but we do argue that they weren't required to get a warrant under the Plainview Doctrine. And to specifically answer your question, I would point you to this court's decision in Texas v. Brown. And in Texas v. Brown, the court discussed containers that were maybe not on their face clearly criminal, but to a trained officer indicated they were containing evidence of criminal activity. In Brown, that evidence was drugs that were held inside an opaque green balloon. And specifically, the officer knew or believed strongly that it contained drugs because of the way that balloon was tied.
So that's the difference here. When they're opening up different folders, is it readily apparent some other crime is being committed without studying the piece of paper? Or is it readily apparent when they look at an account ledger that's not evidence of child abuse?
Your Honor, in all situations, it certainly would not be apparent. But in this situation, respondents argue that it was apparent specifically because of the location of that ledger file. The ledger was contained in a folder normally reserved for files related to the operating system of the computer. It's a folder that individuals who are not committing criminal acts would generally have no reason to ever even go into or be aware of. And so it's not just that they came across this file that said SR Ledger, it's that...
Readily apparent. That sounds to me like a suspicion, not something that's readily apparent of criminality.
Your Honor, in Texas v. Brown, this court specifically said particularly to the trained eye of the officer. And in this case, the officer actually testified that based on his experience, files that were found in this location were likely to be criminal in nature.
Based on some anecdotal evidence that in some other case there was a file that was in a place where it shouldn't have been, and these guys aren't trained computer forensic analysts, are they? Besides which?
Your Honor, they are not trained forensic computer analysts. That is certainly true. And for example, had they gone and sought out this folder on its own, that likely would not have been sufficient to open it, or may not have been sufficient to open it. But given their experience as law enforcement officers, they had a reason to suspect strongly that this file would be criminal in nature in some way. And in terms of what we're looking at here, the specific issue is more directed towards the other Soap Road files that were found in the folder in which the ledger was found. Additionally, petitioner specifically said that they don't contest the seizure of the ledger or the opening of the ledger. They contest the Soap Road files.
What does your client, the state, get the benefit because they're not using specific keywords? They're turning this warrant into a general warrant by using so spacious a word as bill, which is going to cover 99% of areas completely unrelated to child abuse.
Your Honor, first I would like to note that petitioner has not contested the validity of the warrant in any way. They claimed the officers converted it to a warrant when their intent changed.
Well, they used the search word bill.
Correct.
Did they turn this warrant into a general warrant by using such a general search word?
Your Honor, our position is they did not make that change because in this case what they were looking for were doctor's bills, and that could be labeled as doctor bill, hospital bill. Right? What that other word is going to be is something that's much harder to predict.
They could have used doctor and doctor, medical, instead of bill. No?
Your Honor, we don't disagree that
they did use those terms.
Absolutely, and we agree that they are allowed to use those terms. However, that doesn't mean that they would not be allowed to search for the term bill, specifically because they were looking for a bill showing that, a doctor or a hospital or someone had been paid to treat the child, possibly for an injury that is indicative of child abuse in some way.
Counsel, we currently require law enforcement officers to get an additional warrant in a number of different circumstances. For example, in the consent regime, where you give consent to search a room. There may be a locked closet in that room. If you only get consent to search the room, we would require that those officers then get a separate either consent or warrant to search the locked closet. That's the extent. So we do this all the time. Why shouldn't we, especially in light of Riley and our recognition that electronic devices are different than file cabinets, they're different than rooms, require officers to take the additional simple step of going back to a magistrate and getting the additional warrant?
Your Honor, the distinction here falls on the plain view doctrine. We certainly don't contest that there'd be many instances in which an officer would need to go get a second warrant to maybe search different parts of the computer where the evidence is unlikely to be found. However, our position in this case is that a warrant is not required specifically because of the plain view exception. Had that exception not applied here, then it would not have been required.
But plain view means readily apparent, and you're looking at antique lunchboxes and bank routing numbers. I mean, once you see any of those things, doesn't that indicate this isn't about child abuse? I better move on.
Your Honor, does indicate it's not about child abuse. It, however, does not indicate that it's not criminal in some way, and the plain view immediately apparent.
But you can't be connecting the dots when you're looking for evidence of other crimes. Doesn't that suggest it's not readily apparent if you got to spend time and piece things together?
Your Honor, the officers didn't need to piece together exactly what the evidence meant as long as it was holistically, immediately apparent. Certainly, a file that was about an antique lunchbox on its own, respondents agree would not be sufficient to continue searching. That would not be immediately apparent that it was criminal. But seeing a number of files in a folder normally reserved for operating system files that general users have no reason to use, and seeing that things like bank routing numbers are in that file indicates that there is some criminal purpose to those files as a whole.
The touchdown to the Fourth Amendment is reasonableness. Do you meet that standard by using a fourth generation software conducting a search that may turn up all sorts of intimate details about a person's life, rather than getting software that is more focused to uncover the crime?
Your Honor, the software, certainly a software that was incredibly general would not be allowed. Opening every file for just a cursory look, every single file on the computer would not be reasonable. However, these officers, while using search software, did search specific terms that were related to child abuse. They looked for photos that could show evidence of child abuse. So there certainly would be situations in which officers abused that software. In this case... Well,
didn't they abuse it in this case?
Our position is they did not abuse it in this case.
They searched the phone. They didn't have the warrant to search the phone.
Absolutely. In the case of Riley, to which you're referring, they did not have a warrant to search the phone. A key distinction here actually being that they did have a warrant to search the computer. So in this case, the officers did have a reason to be in the computer from the first instance. In Riley, they didn't have that. The officers did not have a warrant, completely warrantless.
They downloaded the images from this phone, and that phone was not specified in the warrant, correct?
You're referring to the images on the phone?
Yes.
Oh, in this case?
Yes.
Yes, the duplicated images on the phone were not in the warrant, but those images aren't a subject of this argument today. We're talking specifically about this.
So do you concede that you went too far when you seized the images from the phone?
We concede that had images in the phone been at issue, that those images could be subject to suppression per Riley.
Let me ask you a question. You suggest that that this introducing the inadvertence requirement here would force officers, when they get their warrant in the first instance, to use the broadest possible terms to get the needle in the haystack. That's your argument in your brief. Before I was appointed to the Supreme Court, I was a magistrate judge, and why can't we rely on our magistrate judges to make sure that only facts that show probable cause are warrants are being granted appropriately?
Your Honor, because it's simply untenable given the number of files and the number of different searches that can happen on a computer. While certainly wanting to perform an entirely new search would require a magistrate, as long as they're within the terms of the original search, having to go to a judge and ask for every single search term, one, could give criminals a key to how to avoid the terms of that warrant, or two, require police officers to constantly be going back and forth between the magistrate and the evidence.
The warrant wouldn't have to be for the search term. The warrant would be for illegal narcotics trafficking.
And that's exactly what this search was for here, was for child abuse, and was sufficiently specific. And had the officers taken that and specifically said, okay, we're searching the entire computer for any criminal, I see my time is up, may I continue to conclude briefly?
Yeah.
Had they searched for any criminal evidence from the get-go, that certainly would not be allowed. However, in this case, because they were searching for evidence of child abuse and then came across this other evidence in plain view in a container, specifically the folder in plain view that had indications of criminal activity that was strongly suspicious, according to the officer's judgment as police officers, of containing criminal information, that under Texas v. Brown, they can look into that folder that was in plain view from their search term, that was within the terms of this warrant.
Thank you, counsel.
And on that basis, we respectfully request that you affirm the opinion of the Court of Cardozo. Thank you.
Thank you very much. Thank you, all counsel, for your fine arguments. Oh, you got a rebuttal?
Oh.
Go. I'm so sorry.
Thank you.
Go ahead.
I would like to briefly address 2 points made by opposing counsel. The first is the characterization of the statements on the record on pages 4 and 5 of the record in the second interview with Mrs. Cabot. I would like to note that at no point did it lose its focus on the petitioner, the accused. The questions continued with, when did he do this to you? And what did he do to you? And it ended with, he pushed you into a bedpost, a leading question, which the child then answered yes. And secondly, the fact that the Section 413 of the Social Services Law does not implicate on its face law enforcement and does not have a legislative purpose to deputize is also not dispositive in this matter. The Eighth Circuit Court of Appeals has noted in Bobadilla versus Carlson, where there was a similar mandatory reporting statute, that where the purpose is to elicit past statements about past events that could be used later at trial, the fact that it wasn't law enforcement is a distinction without a difference. Thank you.
Thank you.
Thank you, Your Honors. In asking you, or in suggesting that the criminal nature of the Soap Road files was immediately apparent, or that the officer's strong suspicions allowed them to open the folders, the respondent is illustrating the deficiencies in the rules that they ask you to adopt today. The fact is, Officers Bennett and Mendez, under the warrant they had, given the rule of the Cardozo Court of Appeals, could have opened any file on that computer looking for evidence of any crime about anyone, including unsuspecting third parties. That is a general warrant that this court has abhorred for 200 years, and we ask for that to continue today. Thank you, Your Honors.
Thank you. Now I think the arguments are concluded. I want to thank all counsel for your very fine arguments, and I think we will retire now and deliberate and come back with an answer. Thank you.
All right. Parties will step outside while the judges deliberate.
We're staying. We're going to stay here? Okay. We'll see you soon. Yes.
Before we